Hey everyone! So in this video, we'll discuss Title 11 or Crimes Against Chastity, which includes Articles 333 to 346. So what are the crimes against chastity? They are adultery, concubinage, acts of lasciviousness, qualified seduction, simple seduction, acts of lasciviousness with the consent of the offended party, corruption of minors, white slave trade, forcible abduction, and consented abduction. So we now begin. So chapter 1 is adultery and concubinage. So the first article is Article 333 or adultery. So adultery is committed by any married woman who shall have sexual intercourse with a man not her husband, and by the man who shall have carnal knowledge of her, knowing her to be married, even if the marriage be subsequently declared void. So adultery shall be punished by prison correctional in its medium and maximum period. So if the person guilty of adultery committed this offense while being abandoned without justification by the offended spouse, the penalty next lower in degree than that provided in the next preceding paragraph shall be imposed. The penalty shall be mitigated. Therefore, it is akin to a mitigating circumstance. So, what are the elements of adultery? First is that a woman is married. Second, she has sexual intercourse with a man who is not her husband. And third, as regards the man who she has sexual intercourse with, he must know her to be married. So, adultery is a private crime. It can only be prosecuted by the offended spouse. So, yung husband nung wife na nag-commit ng adultery lang yung pwede mag-file ng case. Without the complaint filed by the offended spouse, there is no crime. Therefore, the state cannot on its own file a case of adultery against the wife. If the lover does not know that the woman is married, still, the husband should file a case on both of them. It is a matter of defense only on the lover to say that hindi niya alam na kasal yung babae. So there are cases wherein only one of the convicted and the other is acquitted. Then the other article in this chapter is concubinage under Article 344. So, any husband who shall keep a mistress in the conjugal dwelling or shall have sexual intercourse under scandalous circumstances with a woman who is not his wife or shall cohabit with her in any other place shall be punished by prison correctional in its minimum and medium periods, and the concubine shall suffer the penalty of discero. So what are the elements here? So one is the man must be married, that he committed any of the following acts: keeping a mistress in the conjugal dwelling, having sexual intercourse under scandalous circumstances, and cohabiting with her in any other place. And third is the woman must know that the man must be married. So yung kanina, kung alam nung paramour, nung lover na kasal yung babae, here naman, alam nung mistress na kasal yung lalaki. So the wife must initiate the filing of the complaint. Like a while ago, it was the offended husband. Here naman, it's the offended wife. Because it is a private crime, like adultery. Without the complaint, the state cannot on its own file the case of concubinage. The wife must file the case against both of the husband and the concubine. And what if the concubine doesn't know that the husband is married? Kagaya kanina, hindi alam ng lover. Dito, hindi alam ng concubine. It is a matter of defense on the part of the concubine that she was also deceived. She did not know that the man is married, but she also must be prosecuted. So, the first act here is keeping a mistress in the conjugal dwelling. So, inuwi yung mistress niya sa bahay. The conjugal dwelling refers to the house of the husband and the wife. So, the husband brought her to the house. And yung second act naman is having sexual intercourse under scandalous circumstances. So, the best witnesses here are the neighbors of the husband or those who know the couple. It must be in the manner that the neighbors are shocked or those yung mga kilala nila magugulat na merong mistress itong husband. Tapos yung third act naman is cohabiting with the woman in any other place. So cohabitation means that the husband and the concubine were living together as if they were husband and wife without the benefit of marriage. So kung tinira sa ibang bahay, tapos doon na rin tumitira yung lalaki. So we have a problem here. What if A, the wife had sexual intercourse with X, the lover? So si B, the husband, may file a case for adultery against both of them. However, during the trial, sabi ni X, And na-prove ni X beyond reasonable doubt na si A represented herself to be single and that X believed that she was indeed single. So, paano mag-rule yung court dito? The wife can be convicted for adultery and the lover has his defense that he did not know that the woman is married. It is a matter of defense. Pero kailangan pa rin siyang ma-prosecute. And it depends on the court kung ma-acquit siya or mas malolower lang ng penalty niya. So, if the wife is abandoned by her husband without justification, so kung wari, kaya siya nag-cheat kasi in-abandon siya, mitigating circumstance lang to. Adultery is a crime of consequence, so there is no attempted or frustrated stage. It is always on the consummated stage. It is instantaneous. It is an instantaneous crime, and it is consummated upon the carnal union of the wife and the lover of the wife. So adultery, it can be proven by circumstantial evidence. So another example would be, so what if A had sexual intercourse with his mistress Z at Victoria Court Motel? Is A liable under paragraph 2 yung sa scandalous circumstances of Article 344? So the answer here is no, because it was done in secrecy. In order for the husband to be liable for concubinage by having sexual intercourse with a woman who is not his wife, it is necessary that the sexual intercourse was committed under scandalous circumstances. Their sexual congress must set a bad example, misconduct among the people in the neighborhood. Paano kung wari, yung hotel was just beside their neighborhood? And for example, neighbors saw the wife and the husband naglalandian sa labas ng hotel. So it can be an evidence against the husband to prove that he committed the crime of concubinage. So, ayun. Okay. So we go now to chapter 2, rape and acts of lasciviousness. So, rape is already repealed. Hindi na siya under sa crimes against chastity, as we discussed in our video under crimes against persons. In-explain ko rin doon na yung rape na under crimes against persons na siya and no longer crimes against chastity. So, rape is no longer a private crime. So, pwedeng yung kahit hindi yung offended party yung mag-file, pag pinile to ng state, the case can prosper. It is already a public crime and located under Title 8, Crimes Against Persons. So, here, we have two acts of lasciviousness. We have acts of lasciviousness under circumstances of rape sa Article 336. Then we have acts of lasciviousness under circumstances of seduction under Article 339. Ito yung acts of lasciviousness with the consent of the offended party. So ano ba yung acts of lasciviousness? Acts of lasciviousness refers to acts which is prompted by lust or lewd design. So to further explain, acts of lasciviousness in Article 336, it is committed by any person who shall commit any acts of lasciviousness upon other persons of either sex under any of the circumstances mentioned in the preceding article. It shall be punished by prison correctional, and these are the elements. So, that the offender commits any acts of lasciviousness, then the act of lasciviousness is committed against a person of either sex, that it is done under any of the following circumstances, using force or intimidation. Ito yung parang sa rape, when the offended party is deprived of reason or otherwise unconscious by means of fraudulent machination or grave abuse of authority, or when the offended party is under 12 years of age or is otherwise demented. So we have a question. Offender is a woman while the offended party is a man. So the man was being held by two other men. Tapos yung woman, hinubaran niya yung lalaki, tapos touch the private parts of the man. So para tong reverse rape, yung woman yung sa lalaki. So what is the crime committed by the woman? So it is acts of lasciviousness under circumstances of rape under Article 336. So under Article 336, the offender and the offended party may be any person. So pwedeng lalaki or babae. Remember that in rape, in paragraph 1, it says there that the offender must be a male who shall have carnal knowledge of a woman. Although in the second paragraph of rape, in sexual assault, it can be any person Pero here nga in acts of lasciviousness, wala namang sinabing carnal knowledge in our example given. And so it falls under acts of lasciviousness, which was committed by a woman. So the man here was held by two other men, and the act of the woman was prompted by lust or lewd design. Therefore, it is acts of lasciviousness under circumstances of rape, which falls under Article 336. So next is Chapter 3. Oh, I'm sorry, it's typo. Chapter 2 rather. Seduction, rape and acts of, Chapter 2, rape and acts of lasciviousness. Typo to. Anyway, there are two kinds of seduction. We have qualified seduction under Article 337 and simple seduction under Article 338. So first is Article 337 or qualified seduction. So seduction means enticing a woman to unlawful sexual intercourse by promise of marriage or any other means of persuasion without the use of force. So dito, may carnal knowledge, pero unlike rape na there's force, threat, or intimidation, and the other circumstances enumerated therein, here naman, na-entice yung babae into committing sexual intercourse. So, yon, it's by means of deceit or other kinds of persuasions. So what are the acts punished here? So first is seduction of a virgin over 12 years of age and under 18 years of age by certain persons such as a person in authority, priest, teacher, etc. And seduction of a sister by her brother or descendant by her ascendant regardless of her age or reputation. So what are the elements? First is offended party is a virgin, which is presumed if she is unmarried and of good reputation. Second, she is over 12 and under 18 years of age. If the victim is less than 12 years of age, the crime is already rape, statutory rape even. If the victim is over 18 years of age, qualified seduction is not committed. There is no crime at all kasi um sinasabi nila na if there's no force or intimidation here, the woman is not or hindi naman unconscious. Parang meron na siyang sarili niyang will and she can decide for herself. Parang ganun yung explanation. So offender has sexual intercourse with her. If there is no sexual intercourse and only acts of lewdness are performed, there is crime of acts of lasciviousness under Article 339. So kasi sa seduction, may sexual intercourse. Pero kung wala, baka Article 339 kung may consent ng offended party. Then there is abuse of authority, confidence, or relationship on the part of the offender. So ito yung elements ng Article 337 under the first act. So the elements naman for the second act is the offended party need not be a virgin or she may be over 18 years old. Second is the offender has sexual intercourse with her. Third is offender is her brother or ascendant by consanguinity, whether legitimate or illegitimate. So yung sinasabing virginity dun sa, by the way, can I just add, yung virginity na sinasabi dun sa first act, it need not be physical virginity per se. You can still be considered a virgin by this article when you are of good repute nga, when you are keeping your chastity or when you're not having sexual relations with any other man. So hindi naman di bale naman na you have committed before, pero when you're living on a good reputation nga, so they consider that as a virgin. So who are the offenders in qualified seduction under Article 337? So yung nag-abuse ng authority, ito yung mga yon. So person in public authority, guardian, teacher, person who in any capacity is entrusted with the education or custody of the woman seduced. Then those who abused confidence reposed in them, priest, house servant, or yung domestic. Yung domestic, those who reside in one house, so pwede tong temporary lang, pwedeng nagpe-pay lang sila ng board and lodging, they are still considered domestic. So, and lastly, those who abuse their relationship, brother who seduced his sister, and ascendant who seduced his descendant. Dun sa second kind of qualified seduction, by the way, yung sa nag-a-abuse ng relationship, it doesn't matter kung over 18 na yung offended party or hindi siya virgin contemplated under this kasi what requires there is the abuse of the relationship. So the acts would not be punished were it not for the character of the person committing the same, on account of the excess of power of abuse of confidence of which the offender availed himself. Cases under this article usually involves one wherein there is moral ascendancy over the victim, and they often reside in one house. As stated earlier, because it is very intimate, diba? To be living in one space, seduction is more often committed within one's own household. So we now have a problem. So what if a 16-year-old third-year high school student who had sexual intercourse with her 32-year-old math teacher, T, and thereafter became pregnant? Tapos si B, yung mother ni A, filed a complaint of rape against T after discovering A's pregnancy at 6 months. Will the case against T prosper? So the answer here is no, because T is only guilty of qualified seduction and not rape. B may opt to file for a case under Article 337 because the elements of qualified seduction are present. T being entrusted with the education and custody of A, the fact that A gave consent to the sexual intercourse, hindi yun magiging defense ni T. Magiging liable pa rin siya for qualified seduction. Moreover, the accused charged with rape cannot be convicted of qualified seduction under the same information. If any of the circumstances in the crime of rape is present, the crime is not to be punished under this article. Thus, if the offended woman was sleeping or the offender used force or intimidation when the sexual intercourse with her happened, the crime would be rape. Eh dito naman, hindi naman. So, it is qualified seduction. So we differentiate simple seduction and qualified seduction. The distinction between qualified seduction and simple seduction lies in the fact, among others, that the woman is a virgin in qualified seduction, while in simple seduction, it is not necessary that the woman be a virgin. It is enough that she is of good repute. For purposes of qualified seduction, virginity does not mean physical virginity. It means that the offended party has not had any experience before. Although in qualified seduction, the age of the offended woman is considered if the offended party is a descendant or a sister of the offender, no matter how old she is or whether she is a prostitute, the crime is qualified. The crime of qualified seduction is committed. Deceit is not necessary in qualified seduction. Qualified seduction is committed even though no deceit intervened or even when such carnal knowledge was voluntary on the part of the virgin. This is because in such a case, the law takes for granted the existence of the deceit as an integral element of the crime and punishes it with a greater severity than it does simple seduction, taking into account the abuse of the confidence on the part of the agent. Abuse of confidence here implies fraud. So we go now to the next one, which is Article 338, or simple seduction. The seduction of a woman who is single or a widow of good reputation over 12 but under 18 years of age committed by means of deceit shall be punished by arresto mayor. So what are the elements of the crime? The offended party must be over 12 but under 18 years of age. She must be of good reputation, single or widow. Offender has sexual intercourse with her. It is committed by means of deceit. In case of simple seduction, the offended party must be a woman who is single or widow of good reputation. So the offender here is any person who had sexual intercourse with her by means of deceit. And deceit here is that the offended party gave herself to the man because of the latter's promise. So kung may promise na papakasalan kita, ganyan. So that's deceit. It may come in the form of inducement or of a false promise. So to give you an example, sorry, hindi ko pala nalagay. So to give you an example, in order to have sexual congress with the woman, the man promised to marry the woman. The woman who believed the promise gave herself to the man. What crime is committed, if any, by the said man? So here, it is simple seduction because in order to induce the woman to give up her virginity, it was due to the deceit employed. So next is Article 339, or acts of lasciviousness with the consent of the offended party. The penalty of arresto mayor shall be imposed to punish any other acts of lasciviousness committed by the same persons and under the same circumstances as those provided in Articles 337 and 338. So here are the elements of Article 339. One is that the offender commits acts of lasciviousness or lewdness. Two, that the acts are committed upon a woman who is a virgin or single or widow of good reputation under 18 years of age but over 12 years, or a sister or descendant regardless of her reputation or age. Three, that the offender accomplishes any acts of, or by abuse of authority, confidence, relationship, or deceit. So, can a male be an offended party in this kind of acts of lasciviousness? So, note that in Article 339, unlike Article 336, di ba, doon sinabi na any person. Here, it does not mention person of either sex as the offended party. So, dito, ano natin, na woman yung offended party. So, with the consent of the offended party, what does this mean? This phrase is used in the title of Article 339, the offended woman may have consented to the acts of lasciviousness being performed by the offender on her person, but the consent is obtained by abuse of authority, confidence, or relationship, or by means of deceit. So, we have a problem. What if a girl 16 years of age, and B were lovers? While they were in the theater, B kissed A, touched her breast, including her private parts, with the consent of A. Was B guilty of acts of lasciviousness with the consent of the offended party? So the answer here is no. In order that the crime of act of lasciviousness with the consent of the offended party may be committed, it is necessary that the crime is committed under circumstances which would make it qualified or simple seduction had there been sexual intercourse instead of acts of lewdness only. So in the problem given, B did not accomplish the act by abuse of authority, abuse of authority, confidence or relationship, or hindi rin naman siya gumamit ng deceit. So, hindi to magpo-fall under acts of lasciviousness or qualified or simple seduction. So, what is the difference of acts of lasciviousness in Article 336 and acts of lasciviousness with the consent of the offended party in Article 339? Both Article 336 and Article 339 treat the acts of lasciviousness. Under Article 336, acts of lasciviousness, the acts are committed under circumstances which, had there been carnal knowledge, would amount to rape. And in Article 339, the acts of lasciviousness are committed under the circumstances which, had there been carnal knowledge, would amount to either qualified seduction or simple seduction. There may be consent, but there is either abuse of authority, confidence, or relationship or deceit. Diba? The acts of lasciviousness in Article 336, it includes there yung may force, threat, or intimidation, yung deprive of reason yung offended party. While in 339, may acts of lasciviousness, pero may consent nga, pero yun na nga, may abuse of authority, confidence. So, kung nagkaroon naman ng carnal knowledge, yung isa, magiging rape sana, yung isa, qualified or simple seduction, as the case may be. So, Article 340 is corruption of minors. Any person who shall promote or facilitate the prostitution or corruption of persons underage to satisfy the lust of another shall be punished by prisión mayor, and if the culprit is a public officer or employee, including those in government, owned or controlled corporation, he shall also suffer the penalty of temporary absolute disqualification. So, corruption is committed by persons who promote or facilitate the prostitution or the corruptions of the minors in order to satisfy the lust of another. It is committed by pimps, yung mga bugaw, or more commonly known nga yung mga bugaw na nakita natin sa television, or I don't know if you know a bugaw personally, but in the Philippines we call them bugaw. So if the offended party is a public officer or employee, including those in the government or in government-owned corporations, so may additional penalty na there is temporary absolute disqualification. So the other is Article 341, or white slave trade. The penalty of prisión mayor in its medium and maximum periods shall be imposed upon any person who, in any manner or under any pretext, shall engage in the business or shall profit by prostitution or shall enlist the services of another for the purpose of prostitution. So the punishable act here is engaging in the business of prostitution, and shall profit by prostitution and enlist the services of any woman for the purpose of prostitution. Then we have now Chapter 4, or abduction. So there are two articles here, Articles 342 and 343, which is forcible abduction and consented abduction. So the elements of forcible abduction under Article 342 is that the abduction of any woman against her will and with lewd design shall be punished by reclusion temporal. The same penalty shall be imposed in every case if the female abducted be under 12 years of age. So first, forcible abduction is the abduction or the taking away or carrying away of a woman against her will na may lewd design. So The woman may be any person, regardless of age, virginity, civil status. So, ano ba yung mga crimes na dinedisregard yung age, virginity, and civil status? So, one is rape. The other one is this one, forcible abduction. So, for as long as the taking away is done with lewd design, and again, I forget, yung other one pa pala is yung qualified seduction on the second act, yung pag sineduce ng sister or ascendant or descendant. So for as long as the taking away is done with lewd design and against her will, this falls under forcible abduction. So sexual intercourse here is not an element. If by reason of or on the occasion of forcible abduction, the man had sexual intercourse with the woman, it may result in a complex crime of rape with forcible abduction. So the other one naman, the elements in Article 343 are consented abduction. So here, before I say the elements, the abduction of a virgin over 12 years of age and under 18 years of age carried out with her consent and with lewd designs also, shall be punished by the penalty of prison correctional in its minimum and medium periods. So the elements here is that the woman must be a virgin, she must be over 12 years of age but under 18 years of age, the taking away must be with her consent after solicitation or cajolery from the offender, and that the taking away must be with lewd design. So the offended party here is she must be a virgin, and we already defined what a virgin is, over 12 and under 18 years of age, and the offender is any person taking away of the woman must be with her consent. Kung kanina, walang consent, ito yung may consent. It was with her consent because it was made after solicitation or cajolery from the offender. Okay. So, you have to take into account na yung age na 12 to 18 is what makes the crime of abduction. Kasi, you can see, although here, sa forcible abduction, it's regardless of age. Dito lang pala sa consented abduction. So we now have a problem. So, ito. A and B were girlfriend and boyfriend. A was a virgin who was 16 years old. So yung man, 24 years old. The parents did not like the man. So with the inducement from the said man, with solicitation, A and B decided to elope. Nagtanan sila. So B carried away A with her consent and with lewd design and put her inside his house. Nilagay na sa, inuwi na sa bahay niya. That night, while they were sleeping, B tried to have sexual congress with the virgin girl A. However, si A nag-refuse. Nevertheless, the man used force and was able to have sexual congress with her. So what crimes are committed? So the crimes committed are the crime committed is a complex crime of consented abduction with rape. Consented abduction, there was taking away of the woman with lewd design and with her consent. In the course thereof, the man raped the girl because force was used in the sexual intercourse. Therefore, there is another crime of rape. You have a complex crime of consented abduction with rape. Abduction was a necessary means in order to commit rape. So in qualified seduction and consented abduction, acts of lasciviousness in circumstances of seduction, these are the instances, as I said a while ago, wherein virginity is an element. In consented abduction, sexual intercourse is not an element. So if after the woman ran away with the man, yet she does not want to have sexual intercourse, but the man forced her and was able to succeed in having sexual intercourse, the crime committed is consented abduction with rape. Okay. So we now go to the last one. Chapter 5 is provisions relative to the preceding chapters of Title 11. So it's Article 344, prosecution of crimes of adultery, concubinage, seduction, abduction, rape, and acts of lasciviousness. Article 345 speaks of civil liability of persons guilty of crimes against chastity. And Article 346 is liability of ascendants, guardians, teachers, or other persons entrusted with the custody of the offended party. So in Article 344, prosecution of the crimes of adultery, concubinage, seduction, abduction, rape, and acts of lasciviousness, the crimes of adultery and concubinage shall not be prosecuted except upon the complaint filed by the offended spouse. As we said a while ago, this is a private crime. So hindi pwedeng yung state yung mag-file ng complaint, kailangan yung offended party. The offended party cannot institute criminal prosecution without including both the guilty parties if they are both alive, nor in any case if he shall have consented or pardoned the offender. So pwede kasing i-pardon nung offended party yung spouse nila. So, sa offenses naman of seduction, abduction, rape, or acts of lasciviousness shall not be prosecuted except upon a complaint filed by the offended party or her parents. Pero hindi nakasama dito yung rape because rape is already a public crime under under crimes against persons. So, except upon a complaint filed by an offended party or her parents, grandparents, or guardian, nor in any case if the offender has been expressly pardoned by the above-named persons as the case may be. In cases of seduction, abduction, acts of lasciviousness, and rape, the marriage of the offender with the offended party shall extinguish the criminal action or remit the penalty already imposed upon him. The provisions of this paragraph shall also be applicable to the co-principals, accomplices, and accessories after the fact of the above-mentioned crimes. These are private crimes which can be prosecuted upon the complaint filed by the private party. So seduction, abduction, acts of lasciviousness, private crimes dito, which can be prosecuted upon yung mga following: offended party, parents, grandparents, guardians, in the order na I mentioned. So in seduction, abduction, and even public crime of rape, the subsequent marriage of the offended, kasi sa rape, di ba? I think it's Article 266D. It says na yung C or D. It says na yung pardon by the offended party or subsequent marriage of the offended party and the offender shall extinguish the liability and shall remove the penalty already imposed by the court. So in Article 345, civil liability of the persons guilty of crimes against chastity, the person guilty of rape, seduction, or abduction shall also be sentenced to indemnify the offended woman, to acknowledge the offspring unless the law should prevent him from so doing, in every case to support the offspring, the adulterer and the concubine in the case provided in Articles 333 and Articles 334 may also be sentenced in the same proceeding or in a separate civil proceeding to indemnify for the damages caused to the offended spouse. Civil liability of persons guilty of rape, seduction, or abduction to are the following. So, to indemnify the offended woman, to acknowledge the offspring unless the law should prevent him from doing so, and in in every case to support the offspring. And lastly, in Article 346, the liability of the ascendants, guardians, teachers, or other persons entrusted with the custody of the offended party. The ascendants, guardians, curators, teachers, and any person who, by abuse of authority or confidential relationship, shall cooperate as accomplices in the perpetration of the crimes embraced in chapters second, third, and fourth of this title, shall be punished as principals. So, teachers or other persons in any other capacity entrusted with the education and guidance of the youth shall also suffer the penalty of temporary special disqualification in its maximum period to perpetual special disqualification. So, any person falling within the terms of this article and any other person guilty of corruption of minors for the benefit of another shall be punished by special disqualification from filing the office of the guardian. So this ends our discussion on Title 11 or Crimes Against Chastity. Thank you for listening to this video and I hope this helps your studies in criminal law too.